Welcome to episode 20 of my 2 Cents a Zambian Case Law podcast. Wow, we're here. Episode 20. I would like to thank everyone who has for the last 2 years listened to each and every episode. Thank you. And for some of you that have recently joined us and have listened to our recent episodes, thank you very much. So let's get right into today's case at hand. So today's case is a constitutional court judgment that was recently rendered by the court. So it's an unreported case. However, the case is Chrispine S.Muchindu versus the Attorney General of the Republic of Zambia. And the cause number is 2021/CCZ/0034. The area of the law that our case today focuses on is that of employment law, pension law, constitutional law, and also on issues of retirement. Now, what it seeks to determine is who qualifies to be retained on the employer's payroll after the employee's last day of work. The brief facts of the case are that Lieutenant Chrispine S.Muchindu joined the Zambia Air Force as a commissioned officer on 15th July 2011. He went on to serve in this role until he retired from the Air Force. That was on 3rd February 2017. And this was in accordance with the Defense Force Regulation Act and the Defense Force Act, Chapter 106 of the Laws of Zambia. Now, upon his retirement from the force, he was entitled to a pension. And this pension, of course, was supposed to be calculated in accordance with Section 41 of the Pension Services Act number 35 of 1996. And he was also entitled to other allowances, such as 6 months allowance in lieu of notice, housing allowance, and service allowance, and also leave days. Now, the Zambia Air Force kept him on the payroll until they had liquidated his pension benefits. And upon liquidating his pension benefits, he was then removed from the payroll. However, the petitioner, Chrispine Muchindu, was claiming that the Zambia Air Force did not finish paying his pension benefits, and as such, they violated his constitutional provisions by removing him from the payroll, and also the mere fact that they did not pay his pension benefits on time. So he was therefore arguing to say there was a violation of Article 187 to 189 of the Constitution of Zambia, which talk about the payment of pension benefits and the retention of an individual on the employer's payroll up until the pension benefits are actually paid. When Chrispine Muchindu took the case before the Constitutional Court, the issue that he wanted them to determine was whether the petitioner was entitled to be retained on the respondent's payroll following his retirement until payment of his pension benefits. The second is whether the petitioner is entitled to be paid his salary arrears from March 2019 to date. The Constitutional Court found that the petitioner had been paid all his pension benefits, and on that basis, the fact that they were liquidated, the question of whether or not the petitioner was entitled to be retained on the payroll was one that could not happen because his pension benefits were paid. The court also went on to hold that terminal benefits do not constitute pension benefits. This is because the reading of Article 189 states that only pension benefits will allow you to be retained on the payroll. And those pension benefits are granted by or under a relevant act. So if you haven't been paid those pension benefits as a result of a pension law in relation to your employment, you can be retained on the payroll. So some of these pension laws are the Public Service Pension or the National Pension Scheme, NAPSA. If your employer hasn't paid you any of those or any other pension law that is in accordance with your employment, the Constitutional Court said you ought to be kept on the payroll. So they then went on to conclude that the Zambia National Air Force had not violated any constitutional provisions from Article 187 to Article 189. The first, my 2 cents talking point is the Office of the Attorney General of the Republic of Zambia, in accordance with Article 177, Sub-Article 5 and Section 12 of the State Proceedings Act, guide as to how you sue government institutions such as ZAF in a civil matter. So where you have a dispute as an individual with ZAF, the Attorney General is the one you sue. You don't sue ZAF. You sue the Attorney General. Hence, in this case, why you saw the citation of Chrispine Muchindu v. the Attorney General, but yet the dispute arose with ZAF and Chrispine Muchindu. So the Attorney General always represents government institutions. However, he does not represent the Ministry of Finance. They represent themselves. An act of parliament gives them the right. So, in short, you can say government institutions are represented by the Attorney General as stated by the Supreme Law of the land, and the Ministry of Finance is also represented on its own as stated by an act. So the law basically stipulates how government institutions can be sued, who can represent them, and in this instance, the Attorney General can represent ZAF. Number 2, the only employees who can be retained by the employer on the payroll are those who you owe pension benefit, and that pension benefit is not paid to you on the last day. Not retirement or gratuity owed to you. No, only pension benefit. Now, the Constitutional Court has then interpreted the term pension benefit in accordance with Article 189 to mean that which is granted by or under a relevant pension law. It could be the Public Service Pension Act, as with Chrispine Muchindu's case, or even NAPSA or any other relevant law, and it must be in connection with your employment service. So meaning, you can't be on the payroll if you are claiming that you are owed gratuity. No, it must be a pension benefit. And even if you are claiming a pension benefit, it must only be one that is granted or provided for under an act of parliament that relates to pension law, nothing else. So that has been today's case with me. Thank you for tuning in, and thank you for listening to our 20th episodes, and God bless. Bye.